Hey everybody, this is Fariel, your US and Canadian immigration lawyer, bringing you the most up-to-date information on US and Canadian immigration law. In this video, I'm going to talk to you about President Trump's most recent proclamation and also the amendment to the proclamation. So on June 22nd, President Trump signed an executive order that pretty much barred many foreign nationals from entering the United States. Now, this proclamation became effective on June 24th. So this proclamation barred H-1B, H-2Bs, H-4 dependents, J-1, L-1, and also their derivative dependents from entering or accompanying the foreign national or following to join. So specifically, I am going to talk about Section 2 and Section 3 of the proclamation. So Section 2 talks about the suspension, and then Section 3 talks about the scope of limitation. So under Section 2, it says specifically that anybody who is in H-1B, H-2B, and any alien accompanying or following to join, also a J-1, and also L-1, and the alien accompanying or following to join. Under the same proclamation with regards to the scope of limitations, it specifically stated 3 points. So the suspension applies to any alien who is outside the United States on the effective date of the proclamation. So anybody who is outside the United States on June 24th, anybody who does not have a non-immigrant visa that is valid on the effective date of this proclamation, and anyone who does not have an official travel document or advance parole. So at first, this was the scope and also the limitations to the proclamation. Exactly 1 week after issuing the freeze order on June 24th, there was an amendment to the proclamation. So Section 3A2 was amended to state anyone who does not have a non-immigrant visa of any classification specified in Section 2. So as you remember, Section 2 was H-1B, H-2B, J-1, and L-1. So anybody who does not have a non-immigrant visa in one of those classifications that is valid on the date of this proclamation will not be able to enter the United States. So now any foreign national who does not have a valid non-immigrant visa in the category that they want to enter the United States will be barred from entering. Now, there are specific rules for foreign nationals who are outside the United States versus foreign nationals who are in the United States. So first, let's talk about foreign nationals who are outside the United States and what the bars are. So under the amendment, anybody who is in a non-immigrant visa or has a visa in another category, so for example, a student visa or a visitor visa, and they are outside the United States, they will not be able to move to the United States in H or L or J visa. Also, if a foreign national is overseas with an expired H, L, or J visa, they won't be able to get a renewal on that visa. And that's because the consulates have been advised as the Department of State that there will be no issuance of any of these visas till the end of the year. So at least until December 31st. Now, foreign nationals who are abroad on June 24th but have a valid visa in any category, they're able to come back to the United States. And that's because they don't need a new visa to enter the United States, either the foreign national or their dependent, because they've already have a valid visa stamp. So basically what this means that if you are outside the US and you need a new H, L, or J visa, you are out of luck. The consulate will not be doing any visa stamping and will not be issuing any of the new visas till the end of the year. So what about foreign nationals who are already in the United States? Well, under the original order, any foreign national who is inside the United States who holds a valid visa, they can remain in the United States. They won't have any problem. Now, if you are a foreign national and you are in the US and you are on a student visa or a visitor visa, you can do a change of status. Also, if you are in H, L, or J visa and you wish to have an extension of your visa and you're within the United States, you will also be able to do that extension. Now, H-1B holders, if you want to do a change of employer and you are in the US, that is also possible. So if you have been laid off from your employer due to COVID-19, you still have the opportunity to change employers. Now, why are these allowed? Why is the change of status, extension, and change of employer allowed if you're in the US? And that's because any of these applications are done with the USCIS and you do not require a visa stamp. And so if you are traveling outside the US and you are coming back in and you want to come in one of those categories, you will require a visa stamp. So that's why you won't be able to enter the US. Now, if you're in the US and you decide to travel overseas and your visa is valid, then on the date you return, it is also valid, then you'll be able to come back into the US. But guess what? If you were in the US in a valid visa in one of the other categories, so as a student or as a visitor, and then you leave the US, even though you were in a valid status when you were in the US, because you left the US and you'll require a visa stamp to come back in one of the other categories, you'll be barred from entering. Now, this part is even more troubling. So if you're a foreign national and you are in the US on June 24th and you have a valid visa, but you leave the US and then while you're on vacation or out of the country, your visa expires, you won't be able to enter back into the US. Again, this goes to the whole notion that the US consulate or the embassy will not be issuing you visa stamps in H, L, or J. So if your visa happens to expire while you are out of the US, then you won't be able to come back in. So that's a little bit different than what the original proclamation said, because it seemed at that point that if you had a valid visa in any of the categories and if you left the US, you would still be able to come back in. And especially since if you've already held that visa and you leave, it's not really technically like you're getting a new visa because you already held that visa before you left. So that's a little bit troublesome and a little bit difficult to understand where the rationale is with regards to that. And even if you are working lawfully in the US and you have an employer that has sponsored you on H or L and you leave and that visa happens to expire while you're gone, then you still won't be able to come back in. And even though you have an employer there, that doesn't matter. It's the whole visa situation that is of concern. So my final thoughts are this whole entire proclamation and the amendment as well. It's just a series of bullets and there is no real interpretation. And the only interpretation that we have received is a set of tweets from the Department of State. And these tweets seem to be conflicting and inconclusive when you look at them on the face and then you look at the proclamation in detail. If you are planning to travel internationally, I would highly recommend that you seek the services of a licensed immigration lawyer. Now, this is because most immigration lawyers are also part of the American Immigration Lawyers Association, which means that we will receive firsthand information on any clarifications to the inconsistencies. So before you put your visa at risk or you cause yourself unnecessary panic and stress, seek an immigration lawyer to determine what your options are. And my final recommendation to you is do not travel internationally overseas right now when everything is so up in the air and we don't have exact guidance. I hope you enjoyed the content of this video. If you have any comments or questions, please leave a comment below or email us, and the email is in the description below. Turn on that notification and hit the subscribe button below. Till next time, see ya!